afternoon, everyone. This is Osceola Thomas, and we have another weekly session of the Kingdom Mastermind. This is week number 10. And before we get started, as always, I want to take this time to thank and give honor to our sponsor who has graced us with this professional setting and has actually been the technological brain behind the launching of this. So I just want to say thank you to KJ Multimedia Solutions. And so let's give him a round of applause. He's excellent. So this week, as I stated, is week 10, and we're going to talk this week about estate planning. We've covered 9 lessons to date. Last week we had on Brother Kyle, who's a registered or licensed insurance agency with the state of South Carolina and North Carolina. And he talked about final expense planning. And so if you didn't have an opportunity to look at that segment, please go back and watch that video. It's uploaded on our Facebook page as well as our YouTube page, because it's very important to make sure that you have final expense planning in place and instructions for your family so that while they're grieving, they don't have to worry about what you would have liked to have happen when it comes to your funeral or the expenses associated with your funeral. Those instructions will have already been completed, and the funeral home or the morticians, they will know exactly how to carry out your final wishes. So please go back and look at that segment. So this week, I'm going to go through our PowerPoint presentation. As you know, the Kingdom Mastermind, our goal is to build the kingdom of God one family at a time. You know, as Stephen said in the book of Acts chapter 7, the Most High does not dwell in buildings made with hands. So we know that God's house is not the brick and mortar at some centralized location or some physical address. The kingdom of God consists of people. Your body is the temple of God. 1 Corinthians chapter 3 and verse 16. So that's our motto, building the kingdom of God one family at a time. Now, before we proceed, I'm going to start with our wealth affirmations. The scriptures declare that as a man thinketh in his heart, so is he. Now, if you put that in layman's terms, it basically means thoughts become things. So what are our wealth affirmations? I am worthy of having more wealth. Financial freedom is my birthright. Money comes to me easily and effortlessly. Wealth constantly flows into my life. My actions create constant prosperity. I am grateful to be financially free. Those are our weekly wealth affirmations, and we believe those things. And because we believe those things, we believe that God is going to manifest them as a reality in our life. So let's do a review. Over the last 9 weeks, you should have accomplished, these are the things that you should have accomplished, and I'm going to do a review. You should have definitely did a review of your finances, 3 months of your finances, bank statements, credit card statements, just to get an overall view of where your money is going. Number 2, we talked about automating your expenses, having 2 checking accounts and 2 savings accounts. And if you want to understand why we asked you to have 4 accounts at a financial institution, please go back and look at the second lesson of the Kingdom Mastermind, and you'll understand why you need those 4 financial buckets. Number 3, you should have created a debt elimination plan. We talked about using the snowball method to eliminate debt. And if you want to understand the snowball method and how to put this plan in place to eliminate your debts one at a time, please go back and look at that segment. Number 4, we talked about strategies to increase your credit score. We discussed how that number or how the credit reporting bureaus come up with that 3-digit identifier or credit score. And so we gave you the strategies to put into place to increase your credit score and your FICO score. Number 5, we talked about creating a home-based business, because the goal is to minimize tax liability. So you want to pay as little taxes as possible. And the goal should be to get a refund. So that lesson shared with you all of the tax strategies of a home-based business and why everybody in America needs a home-based business, because businesses pay less taxes than W-2 employees. As a matter of fact, they pay less taxes than all tax categories collected by the Internal Revenue Service. We also talked about selecting the proper credit card. And based on your credit score, I gave you a list of credit cards to take a look at, and you had the autonomy to choose the card that best met your needs based on whether you wanted cash back rewards, hotel rewards, airline miles, etc. But you had the opportunity to look at what you qualified for based on your credit score, and I asked you to start using your credit cards and not your debit cards, because debit cards don't give you anything back. Credit cards give you rewards and perks, but the goal is not to use a credit card as free money, to use the credit card based on the funds that you currently have in your bank account. We also talked about consulting with an insurance agent, and that was for your final expense planning, and that was last week. And this is our final week, and so we're going to talk about, again, estate planning. It's very important for you to have an estate plan. Now, I share with you, I do not teach anything that I'm not doing myself. I have credit cards. That's what I use. I use my credit cards. My credit score, I'm in the 800 club, looking at the 850 club the end of this year. So my credit score is there. I have 4 financial accounts. I have investment accounts. Everything that I'm sharing with you is what I'm practicing. And to date, I'm debt free with the exception of my mortgage. And when I had this house built, I paid half of it off before we moved in. So now the other half of the mortgage is what I pay every month. And I do that. I have it broken down into 2 payments to the lending institution a month. So the 1st to the 15th, they'll get the first half of the mortgage. The second half of the month, they'll get the remaining balance. Just by doing that, making bi-weekly payments, my 30-year mortgage have now went down to a 24-year mortgage. And I'm going to give an additional payment every year, which is going to take it below 20 years. So I've just shaved off more than 10 years off of this mortgage, not to mention the fact half of the house was paid off before we even walked in. And that's the only debt I have. And I do that sharing these strategies with you so that you also can be debt free. And why do I do that? I could go out and buy a new car. I could go out and assume other liabilities and expenses, but I'd rather have control of my time. My goal is to be financially free. So while I'm not a multi-millionaire or a billionaire, I have control of my time. No one tells me when to get up. No one tells me when to go on vacation. I control my time because I have minimal debts. That's the lifestyle that I lead. So with this estate planning, let's first deal with the definition. So what is estate planning? Estate planning consists of transferring, is where you transfer your assets at the time of your death. That's what an estate plan does. It's the vehicle that transfers your assets at your time of death or your demise. That's what the plan does. It also anticipates what can complicate that transfer. So with an estate plan, wherever there's complications such as probate, an estate plan will make sure that you can avoid those barriers and those assets can be transferred to your beneficiaries seamlessly without having to go through the courts. Number 3, it provides you with strategies to reduce complication. So that's what an estate plan does. It's a strategic planning document to make sure that your assets are transferred at your time of death. Okay, so the to-do list. And everyone, if you have friends that want to join, I sent everyone the link. We're on livewithkennethj.com. So if anyone wants to invite a friend to click on, we're on livewithkennethj.com. So our to-do list, this is what I want you to do when it comes to your estate plan. I want you to fill out your beneficiary forms and check to make sure that those beneficiaries are correct. Some people have beneficiaries and it could have been a spouse and now they're divorced and they haven't changed their beneficiary forms. Check to make sure that whoever you have listed on your beneficiary forms are the individuals who you want to transfer your wealth to at your time of death or your demise. So that's what I want you to do. Check your beneficiary forms. Number two, think about guardianship for your children. If you have minor children or special needs children and you were to leave this earth prematurely, do you have someone named in place to take care of your children, to assume responsibility for the care of your children? So I want you to think about guardianship. Next, write a last will and testament. And when I'm giving you this to-do list, I want you to consult with a legal professional, an attorney, to make sure that this is a valid contractual document. So when I say write up the last will and testament, that's the person that will be drafting your last will and testament, is your attorney or a legal professional. Also, your advance directives. Advance directives consist of the living will, that's your healthcare directive, and also your power of attorney. It's also called a durable power of attorney. That's the person that can act in your behalf should you become incapacitated. So I want you to think about that durable power of attorney and also your last, or your living will, should I say, which is your healthcare power of attorney or healthcare directive. And last but not least, set up a living trust. So that's the to-do list. So I just shared with you, number one on the to-do list is to check your beneficiaries. Now, what is a beneficiary? I know this is elementary, but I don't want to assume that everyone knows. I want to test those assumptions to make sure they're valid. So I'm going to start with the elementary level. A beneficiary is a person who will receive money from your life insurance, or any bank accounts or any other accounts, investment accounts, at the time of your death. So whoever receives any type of finances, whether it's from your life insurance policy, as I say, you have stocks, mutual funds, etc., or your checking or savings account, that person is called a beneficiary. Who you have listed as your beneficiary, I'm sorry, I just need to go back to that last slide. Okay, so who you have listed as your beneficiary supersedes what's written in your will. Please understand that. Whoever you have listed as your beneficiary, it will supersede whatever you have written in your will. So if you have, I want my children to receive an equal share of the proceeds from my life insurance policy, but your beneficiary is an ex-wife, at the time of your death, the proceeds of that policy is going to your ex-wife because she's still listed as the beneficiary, even though in your will you said, I want my children to receive it. Whoever is documented as your beneficiary, it will supersede what's written in your will. So make sure whatever you have in your will, that it also aligns with the individuals you have listed as your beneficiaries. So please do your homework and follow up and check your beneficiary forms. Also, check with your life insurance agent about how to change your beneficiary forms. So when it comes to your life insurance policy, reach out to your agent and let them know, I want to review or make an alteration or revision to my life insurance policy when it comes to the beneficiaries I have listed. Secondly, guardianship. That was the second thing I had listed on your to-do list, guardianship. Now that guardian or guardian plan, again, it's going to state specifically who you want to care for your child at the time of your demise, should you die prematurely and your child is still a minor or your child has special needs. So that's something that you definitely want to think about. So this person will assume the responsibility of enrolling your child in school, making medical decisions, legal decisions, etc. So you definitely want to think about, who would I want to care for my child in my absence should I die prematurely? and you want to make sure you put that person in your will. And you see, as I have stated here, have an attorney to draft this, excuse me, have an attorney to draft this in your will. Without a guardianship plan, your children will become wards of the state, and the state will make decisions. So take the time now to think about who you would want in place as a guardian to care for your child, and make sure you put that information inside your will. Have it documented by your legal representative, your attorney. Next, let's talk about the last will and testament. Every person should have a will. And I share with you, I don't say things without practicing it myself. So this is, make sure I put it in front of the camera. This is my will here, drafted by my attorney. This is my wife's will, drafted by my attorney. So every person should have a will. Now it says here, everyone in America has a will, even if they never paid for one. I put that there for a purpose. Every state has laws that dictate the value of your house, your bank accounts, your cars, etc., and how those assets will be distributed at time of death if you do not have a written will in place. So if you don't have a written will in place, by default, the state has created one for you, and the state will determine how those assets are to be distributed. So if you do not draft a will stating specifically your wishes, by default, the state has one in place for you. So in your will, you need a plan. This plan will direct where your property goes. You can do, for example, wills, insurance policies, trusts, minor children, special requests, etc. All of that will be documented in your last will and testament. Your last will and testament is basically your wishes, how you want your assets distributed, who do you want to provide guardianship for your children, and how you want your assets distributed to your heirs. Now, a will makes clear your wishes regarding the distribution of your property and the guardianship of minors. So I just shared that with you. So the executor, that's the person who will make sure that your will is carried out. They're called the executor. They will settle your estate, paying off your debts, your taxes, and distributing the remaining funds to your beneficiaries. That's what the executor of the estate does. And one of the things, Brother Kyle last week talked about insurance. One of the reasons I'm so big on insurance is because I want you to think about this, family. When you die and you have an insurance policy in place, you create an automatic estate. So if you have $1 million insurance policy and you die, you automatically create a $1 million estate at time of death. That estate could pay off your house, it could pay off your debts, and then you have left assets, monetary assets to your children. That's the power of life insurance. So you want to make sure that you have life insurance, that the beneficiaries are stated, and that how you want those assets delegated or distributed, they're within your will, your last will and testament. So your executor, upon settling your estate, will be able to carry out your wishes within your will, and the state does not have to put in their default last will and testament. So it's something called a self-probating will. A self-probating will allows a decedent, or the person that has deceased, to bypass the probate process. You can bypass the probate process. How? When you have a will drafted, you must have witnesses. Those witnesses must sign and attach affidavits to the will certifying that the decedent, which is yourself, was of sound mind when they signed the will and was not coerced into signing. So when I had our will drafted, my wife and I, we met with the attorney and the attorney's paralegal, and we went through the document line by line, page by page, and then we signed the document in front of the attorney and the paralegal. And then they signed as witnesses. and it was notarized. So that's how you avoid probate, because you have witnesses stating at the time of the signing of this last will and testament, they were of sound mind and they were not coerced into signing this document. So remember, it's called self-probating will. It's where you have a written will, and it's written and it's documented and it's signed in front of two witnesses. Now, an important note, and I put this here for a reason, because you have individuals who live together, they cohabit, they cohabitate. You have people that have what they call life partners, and those individuals are not documented in their will. But if you have a life partner, it may be your decision that I want to leave my assets to my life partner. If you're in a same-sex relationship, you might want to leave your assets to your partner. Now, if it's not documented in your will, your family does not have to honor that. And you see what I have here? It would be prudent to have a will in place because your family members do not have to honor. It's called the unofficial relationship. That's what it's called, an unofficial relationship. You might say, well, that's my life partner. That's the person that I built this with. They've lived with me for the last 10 or 15 years. It doesn't matter. Your family does not have to honor an unofficial relationship if you do not have it documented in your will. So you want to take the time, meet with an attorney, have your last will and testament drafted, sign it before two witnesses, and have the two witnesses sign it, stating that you want to leave your assets or have your wealth transferred to your life partner or whoever the person is in this unofficial capacity. You want to leave it to them, and then your family, even if they contest it, the will should hold up because you are in your sound mind. You won't coerced when you sign it, or when you signed it rather, and it was done in the presence of two witnesses. So it's a self-probating will. Now, a living will, and I have that too. So the living will, this is my living will here. See, I can put it in front of the camera. So this is my living will. The living will, there are two primary, it's called advanced directives. That consist of your living will and your durable power of attorney. So the living will, it basically states your medical wishes. So whether or not you want to be resuscitated, whether you want pain medication, tissue donation, etc. That's the living will. Everybody needs a living will. I shared with my wife. We met with the attorney, and we had to go through the process of creating our living will. The attorney was asking all kind of questions. One of the questions he asked was, do you want to be kept alive by a machine? My answer was no. Do you want to be made comfortable with payments? Yes, I want to be made comfortable with pain medication. So the answer to that was yes. So all of that's documented. You don't want to put a person in a position, you're incapacitated, you're in the hospital, you can't make decisions. The likelihood of you living in a non-vegetative state depends on certain medical procedures, and that person is sitting there wrestling. What would Osceola want me to do? Would he want to be kept on a machine? Would he want them to give him blood transfusion? And now that person has to make these decisions, and they're stressing, dealing with all kind of anxiety, wondering what your wishes would have been. Don't put a person in that position. Make sure your living will states specifically what you want done should that take place, should you become medically incapacitated. That's the proper phrasing. So you definitely want to make sure you have a living will drafted. And again, you're doing this with an attorney. Next, we have the durable power of attorney. So what I just shared with you, that was the living will. The living will deals with the healthcare or the medical aspect. Under the durable power of attorney, this person has the ability to operate and act on your behalf when you are not in a position to act on your own behalf. If you become medically incapacitated, somebody has to make not only medical decisions, but financial decisions, etc. Maybe even decisions about your children. This durable power of attorney will handle that. And I also have a durable power of attorney as well. And that's this document here. So this is my durable power of attorney here. So you want to make sure that you have that in place as well, your durable power of attorney, so that in case anything happens, that person is able to step in and they're able to make decisions on your behalf. Next slide, please. Okay, so after you've taken care of your advance directives, you've taken care of your living will, you've taken care of your durable power of attorney, you also have your last will and testament in place. You want to create a trust, a living trust. Now, there are two types of trusts. An attorney can draft your trust. Once he creates the trust document and there's an EIN assigned to the trust, you can then begin transferring assets directly into that trust. And your attorney can help you set up a living trust. And it's a trust that's in place while you are alive, which is why it's called a living trust. So now with these trusts, there are two types of trusts. But trust, the functionality of a trust, and I have a trust. The functionality of a trust is designed for people who have sizable assets in real estate or in business. Uh, it allows you to stipulate certain conditions to be met before heirs receive inheritance. That's very important. So if you have a trust, you might have assets assigned to that trust. It could be your insurance policy proceeds, it could be real estate, whatever it is. But a stipulation is my beneficiary cannot receive the assets from this trust until they graduate from college and they must have a C average. I'm just putting something out there. You could put that stipulation in place. The heir cannot receive the assets until they're married and they produce a male heir to carry on the Thomas name. You can put that, that can be a stipulation. So when you create a trust, you can create stipulations that the beneficiary would have to adhere to in order to access the proceeds that are held in trust. Now, there are two types of trusts. You have a revocable trust and you have an irrevocable trust. And I'm going to share with you the difference. So you have a revocable trust and an irrevocable trust. So the revocable trust is basically one that you can change while you are alive. As long as you are living, you can always make changes to the trust document if it's revocable. And that's exactly what the definition here says. You can put assets into this particular trust, and while you are alive, you control it, and you can make changes to it, and also how you want to disperse assets to your beneficiary. So you have the autonomy to make all of these changes and revisions to a revocable trust as long as you are living. Now, when it comes to an irrevocable trust, with an irrevocable trust, you can't make any changes without getting the permissions of the beneficiaries and all that hold an interest in this trust. Now, revocable trusts, even when I spoke to my attorney, now the definition here says 500,000. My attorney said 1,000,000. But generally, irrevocable trusts are put in place by those that have a large amount of assets. So if you have 500,000, over $500,000 in assets, then you certainly want to speak to an attorney about an irrevocable trust to see the benefits of that. But I always share with my clients a revocable trust. The reason being so you can make changes to the trust while you are alive, because you may change your mind. You may have additional assets coming in. And that's another thing. Once you have your trust document put in place, make sure you put all of your assets into that trust, because if those assets are in the trust, then you can bypass probate with those assets. That's the protection that the trust provides you. You can bypass probate. An important note, and I just shared this with you, a good lawyer should be consulted to make the estate plan. So this is a legal document. So you definitely want to meet with an attorney, and you want to meet with an attorney who resides within your state so that your estate plan is in accordance with the general statutes of your state. So if you're in North Carolina, you want to meet with a North Carolina attorney. I'm in South Carolina, so of course I met with a South Carolina attorney. If you're in New Jersey, a New Jersey attorney, etc. So make sure that the attorney you meet with resides within your state. So whatever the planning document that he or she creates, it will be in alignment with your general statutes and it'll hold up in court. So that's the end. Remember, when it comes to your estate plan should consist of your last will and testament. That last will and testament will not supersede your beneficiaries or your beneficiary documents. So when you create your last will and testament, that's your final wishes. Make sure whoever you're leaving assets to in your last will and testament, that those are the individuals you have listed as your beneficiaries. If that's not the case, then follow up with your insurance agent, follow up with your financial institution, look at your investment or brokerage accounts, and make sure that those individuals are listed. Also, your guardianship plan. If you have young children, please make sure if you have minor children or special needs children, that you have a guardianship plan in place. So should something happen to you or you die prematurely, that you have someone named and a plan in place for them to step in and provide guardianship to your children. So you definitely want to make sure you have a guardianship plan in place, and that's another issue that you'll talk to your attorney about. The last will and testament and your guardianship plan, and we talked about your advance directives. Your living will. Your living will is your healthcare power of attorney. Make sure that you have it documented what you would want should you become medically incapacitated. Do I want pain medication? Do I want a blood transfusion? Do I want to be kept alive on a machine? Make sure all of that's specified in your healthcare power of attorney. Then your durable power of attorney, which is your financial power of attorney. Make sure you have someone named who can step in and handle those affairs on your behalf. And make sure it's someone who you trust. Also, we just talked about creating a trust, a revocable trust, so that you can place all your assets into this trust and bypass probate. But remember, I also shared with you that when you do the last will and testament, you want to make sure that you sign it in the presence of two witnesses and that those two witnesses also sign it and that it's notarized. The reason you want to do that is because you want your last will and testament to show that I was in sound mind and I wasn't coerced into signing this document. So that's your estate plan. Family, please make sure you put an estate plan in place, because if you don't, the state has a plan for you and they will make a decision as to how your assets are distributed. And for you to work hard and to obtain all of these assets, the last thing you want is for the state to then make a decision as to what happens to them. So congratulations. This is week 10. You've completed 10 weeks. I really pray that everything that I've shared with you, that you take the time to go back and make sure that all of these things are in place. If all of these things are in place, then you should be at a position, or at least have a blueprint to start following, to put you into a position where you are financially whole. That's my prayer. That's why I started this 10-week Kingdom Mastermind. And now, before I end this last week of the session or of these classes, I don't know if there are any questions. Well, all right, family. Again, I want to thank our sponsor, KJ Multimedia Solutions. Brother Kenneth has been a blessing, and I thank him for creating this platform so that we can bring this message to you. He and his business, very professional, and every week I'm just in a state of awe about how professional he is and the platform that he's created. I love you, family. Peace and blessings upon you and your offspring. And I pray nothing but prosperity upon you spiritually, mentally, and physically. In Jesus' name, have a good evening. Bye bye.